All right, we're back with Barry Cepelewicz here, and Barry and I are talking here on the Healthcare Business Network. We're discussing audits and what's involved with an audit, how do you respond to one, what are some of the surprises, some of the challenges with an audit, either it's from a third-party commercial insurance company or it can very well be from the federal government. So the next question, Barry, I wanted to hit upon was settlement. If the parties settle, is there a need for a settlement agreement?
Yes, there is a need for a settlement agreement, and that's something that many physicians don't realize when they do the negotiations on their own. And there's an art to getting a settlement agreement that covers many of the issues that I think are important. For example, you would like to get a broad general release that would preclude the third-party payer from coming back at you for claims from the same time period that they were investigating you, which resulted in a settlement. You want to make sure that you have closure. If you're paying money, whether it's $1,000 or $10,000 or whatever amount of money you're paying, you want to make sure you get closure, and that's why it's important to have a release. If you don't have a release, then they theoretically can come back to you on other issues involving claims of the same time period, and then you're back to where you were before, and I'm sure it's very frustrating. You also want to make sure there's non-disparagement language in there, so they can't disparage you in any way, that there's a confidentiality provision in there, so they treat the whole audit process and the findings in a confidential manner. You want to make sure that the audit and the settlement cannot be used as evidence for future allegations. So, for example, they can't come back to you later and say, "Oh, well, we're withholding, payment on these claims because, we audited you 5 years ago and, you settled, and now because of your prior history, we now assume that you're doing the same thing again." No, we have to make sure we have total closure. We want to make sure there's a provision in there that says that, the payment of settlement is not an admission of liability. That's many doctors obviously want to make sure that that's in there because they don't want to admit liability. And finally, we'd like to get maybe a provision in there that to the extent that there has been a report to a third party, like I mentioned earlier, maybe to the Department of Insurance or something like that, then if the physician wants a retraction letter, then the payer would send a letter of retraction saying that they've resolved the audit and there was no finding of fraud or something like that. Some payers will agree to that, some payers will not. But if you don't ask, you certainly will not get.
If you win, Barry, can you recover costs? That's always a big issue because the legal costs, you might be perfectly in the right, but you've had to defend yourself. And now it comes up, the carrier, whether it's the government or a private carrier, comes back and say, "Oh, yeah, by the way, you were right." But now you've been stuck with tremendous costs. Any way to recover that?
Highly unlikely.
Highly unlikely.
And it's highly unlikely that you'll win because at the end of the day, what you do have to understand, Ron, is that many physician records, while the records do have the information that a physician would understand, many, many times the medical records do not contain the information that would justify the actual claim because you didn't follow the AMA CPT code guidelines with all the bullet points. And so there probably are some deficiencies in the record. Whether those deficiencies rises to the level to result in the findings that the third-party payer has and the extrapolation, that's where I disagree with them many, many times. But at the end of the day, there probably is some places where the physician probably would concede that there are issues, and so probably, if anything, money does go from the doctor to the insurance company at the end of the day. So it's very rare to get a win. I've had occasions, but by and large, most of the time, there's usually a payment. Obviously, far less than what they're asking for, significantly less. But there's still a payment made, and that's why you do want to get a settlement agreement.
Now, getting back to what I brought up at the beginning of the show about RAC audits, recovery audit contractors. That's the newest and hottest thing, and I know we're getting many, many questions about that. Explain what's a RAC and how does a RAC audit work?
Well, it's developed by CMS. It focuses on, trying to recoup payments. There was a 3-year demonstration project that CMS had, and it was very, very successful. I think they recouped about $1 billion. And basically what the RAC audit does is it targets providers and suppliers who submit claims to Medicare. And the bases for recoupment that they're looking for are really, there are many bases, but the 3 primary ones are medical necessity, which is probably the most significant basis, incorrect coding, E&M, and duplicate billings and services.
Now, these are private companies, these RAC auditors, correct?
Correct. They typically, the way they typically work is that You'll have nurses and certified coders and therapists are reviewing the records. Physicians tend not to be reviewing these records, but there is usually a medical director involved, and there's a certain limit to the amount of medical records they can request. It's usually based on the number of physicians, I believe, in the practice. And I think there's a 3-year look back. So they, from the date of the initial payment, but they can't, I think, go any earlier than October 1, 2007. Now, there are actually 2 types of reviews. There's what's called a complex review and an automated review. A complex review usually takes place when the RAC believes that there's a high probability of overpayment, and if there is a high probability, then the RAC will need to review the medical records. But if the RAC believes that there's a certainty of an overpayment, then believe it or not, the RAC does not have to even review the medical records. Then you have what's called an automated review. And the question is, well, how do they come to the determination that there's a certainty of an overpayment? And typically what that means is that there's either a violation of some sort of a clear policy of the payer, or that the services that are being provided are what we're referred to as medically unbelievable, whatever that means.
Mm-hmm.
Or if the doctor fails to timely respond to the medical record request, they're going to say, okay, then if you don't want to give us the records, then we're not going to look at the records, and we'll basically do an automated review.
And these RAC auditors are paid they get a commission for what's recovered.
Yes, they are compensated on a contingency basis, which means they obviously have an incentive to find fault.
Correct.